Assalamualaikum and a very good afternoon to all the welcome to our event on the membership drive on the free webinar Employment, Termination and Layoff Benefit Regulation 1980s of membership and also strategic communication of MEF. And then the second part will be presented by our Executive Director, Datuk Hj Shamsuddin Bardan on the topic as per confirmed earlier lah. So without further ado, I would like to invite Puan Haji Haslina to deliver her presentation. Persilakan Puan Haslina.
Okey, terima kasih Cik Nur Khalida. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. A very good afternoon, tuan-tuan dan puan-puan who are online. So I will share with you my slide, which I will take about half an hour to introduce you to what MEF is and what we do, the services that we provide to employers at large. Okay. All right. So for those of you who are quite familiar with MEF, you treat this session as sort of like a breather for you, for which I believe some of you may have heard of us or you are already our member, but you do not know the entire spectrum of what our services are. So just take this session, you to get yourself familiarized with all the entire spectrum of MEF roles, functions, and services. Yeah. Okay. Now, this is a virtual tour for those of you who are online on what MEF is. We are actually the point of reference for the views of employers in the country. And for MEF, the name is Malaysian Employers Federation. We express business needs of the employers in the country. And we also, as you can see, the slides which I'm sharing now, these are the clippings of the newspaper reports that feature MEF views here in the mass media, both in the printed media as well as on the electronics media. Okay, so in short, MEF is a place of where employers or HR personnel seek professional assistance, particularly when you face any issues or problems or you would like to get guidance or consultancy on employment matters, okay? So MEF is actually the central organization of private sector employers in Malaysia, where through our establishment for the last 63 years, we have got the recognition as the representative of the employers, particularly the private sector employers at the national, regional, and at the international levels. Okay, so for the milestone of MEF, we were established way back in May 1959, and as of now, year 2022, we have gained trust representing the interest of about 6,000 plus over ordinary members and 28 industry groups comprising of industry groups, yeah, the association members, okay? And for MEF, where I am currently broadcasting is actually the headquarters, and we are also operating from 2, 4, 6 more regional branch offices nationwide. Yeah. Okay. When we claim ourselves to be the employers rep, being recognized at the national level, as you can see, these coming 2 slides, these boards or councils represent the tripartite, yeah, the tripartite representing employers, employees, as well as the government views. Okay, as you can see, the top over there is NLAC, the highest body discussing labor issues in the country. And then we also have like a representative in the Wages Consultative Council, in the EPF board, in MPC board, NCOSH, NIOSH, HRDC, and so on. Okay. Also, we also have a representative in SOCSO board, yeah, and as well as TVET, as you can see there. Okay, now, so when we say that we are being recognized at the regional level, MEF is a founder member of ASEAN Confederation of Employers, as well as a founder member of CAPE, which is the association or the federation of all the employers within Asia Pacific, yeah, for CAPE, and for ASEAN is for the ASEAN region. Okay, and further beyond the seas, we can see that MEF is a member of IOE, International Organization of Employers, where I believe we have more than 150 employers from all over the world who are members of IOE. And we also have representation at the ILC, which is the International Labour Conference, which is held annually in Geneva. Okay, now, so MEF, when we claim ourselves to be significant in the national level, the proof is that we participate very actively in various government dialogues, and we also make representations on various matters, as long as the matters are of the interests and of the business interests of the employees in the country. Say, for example, like even we participate in the budget dialogue, we participate in the MITI dialogue, as well as other associations, and we present the various matters of interest to the government, yeah, through our representation in the various boards, which I mentioned to you earlier. Okay, now, so what do we do to employers? Okay, as you can see on the slide now, I am sharing with you the 5 major or main services that we provide to employers at large, particularly our members. Okay, number 1 is IR, Industrial Relations. Yeah, the short form is IR, Perhubungan Perusahaan. We also have a service to members in which our big data research and information team provide services such as survey and whatnot, which later on I will be touching on that. We also have IT services, OSH services, and last but not least is training services. Okay. Okay, now, please focus on this slide now, in which when I mentioned earlier on that we provide services to employers, particularly to our members, okay, our services are actually divided into two categories. Yeah, one is free-based services. The other one is fee-based services. Okay, free-based services. These are the services because as you are our member, you pay the annual subscription, which is very minimal, in which you will be getting free services such as number 1, like advisory, guidance, yeah, by phone, email, fax, through our members portal, through our WhatsApp group, and then even through a face-to-face, in which if you have any issues in particular you want to discuss with our consultants, you can make an appointment and see our consultants in our office premises. Okay, this service is provided FOC free because you are our member. Okay, number 2, you will also be receiving email blasts on regular basis. Our email will consist of, say, for example, if there are any like changes in the ACTA, or maybe new regulations, or maybe sort of like new guidelines or whatsoever issued by the government, we will send you by email. Yeah, so you will be getting all the email blasts, and for each company, 4 persons within the organization, which are our members, will get the email blast. Okay, right now. Number 3 is simple written opinion. Okay, simple here means, say for example, you already have the draft or maybe the letter which your company has been using for decades, for example, and you would like to get our view, so and so Dato, or maybe sir, can you please have a look at this the document, simple lah, simple written opinion, that one is free lah. Kalau complicated and then you want us to redraft, or maybe you want us to start from scratch, then it will fall under fee-based services. Kalau simple written opinion, it is FOC. Okay, now, another service which is free is monthly meetings. Of course, as a member, you do not face problems every day lah for you to be in contact with us. Say, for example, you have problems with your employees. Contoh lah, issues like disciplinary problem, or maybe ataupun abuse of sick leave ke, contoh lah, only then you will contact us. Tapi as an HR practitioner, it is best that you keep yourself abreast of all the new things in the HR, in the IR, through our monthly meetings, because our monthly meetings provide a platform for HR practitioners within our membership to discuss current issues, current disputes. Okay, and monthly meetings also will be a platform where, say, for example, if there are new things, which are being perhaps announced by the government, you would like to have a briefing from the respective authority, we will then invite the authority to address the members through our monthly meetings. That can also be done. So this is also part of the freebie. So it's something like, for HR practitioners to keep them updated on the latest IR or any employment laws in nature. Okay. And then next, as you can see there, is you can have access to MEF members portal, because as a member, you will have a better view, or we will give you like the IT services. Yeah, we will provide members portal for you, and there is also an interactive column, ask MEF, something like that, in which you will learn much more on IR issues from the members portal. Yeah, all right now. And then WhatsApp group, okay. Beginning last year, where we used to have groups of companies practicing the work from home mode. So we created this WhatsApp group based on locations, and we have many groups in which you can have an interaction with our IR consultants who man or who manage the group. Okay, so these are the free-based services. Okay, we move to the fee-based services. Fee-based services, of course, if let's say you have court matters, court representation here means industrial court and labor court. Okay, there's no need for you to find lawyers outside there, because our IR consultants, the IR team, they are specialized in these employment matters, and they do this day in and day out. So it is all within their fingertips. They can do court representation for you, okay, with a minimal fee. Okay, now we also have consultancy packages. Consultancy packages here, is more like you want us to do like HR audit, OSH audit, say for example, even IR audit. We also can do like a handbook for you, whether it is you want us to start from scratch, or maybe you already have the document, you want us to review your handbook or your terms and conditions of employment. So that falls under the consultancy packages. Yeah. So we will see on the complexity of the document, then we will give you a quotation. Okay, for these two services which are chargeable, you need not have to worry, because we do not sacrifice on the minimum fee that we charge, because our IR consultants team, we have very experienced and pool of talents and experts in the industrial relations area. Okay, now for seminars, webinars, and conferences, of course, we will have two tier of charges. Members, different rate. Non-members will be a different rate. Okay, just bear in mind, for court representation and consultancy packages, they are only applicable to members only. Yeah, all right now. But for seminars, webinars, conferences, we open to members and members. Same goes with our trainings and publications rate. Yeah. So these three, they are also open for members and non-members with a different rate. And our courses are claimable from HRDC. Okay, now I move on to the next slide. So for industrial relations, just to recap what I mentioned to you just now, advisory, phone, by phone, fax, email, face-to-face, yeah. And then we also have group interaction via WhatsApp. We represent members in court cases. We also do conciliation at Industrial Relations Department, monthly meetings. We also conduct training on IR training, be it public or we call it in-house course training. Yeah, we can do that. We also do IR and HR audit. Okay, now, this is an upcoming IR event which is going to be held next week. Okay, please do not miss out this golden opportunity for you to meet up face to face, yeah, with the experts that we have carefully selected on the speakers, yeah. All right, now, so for this particular IR event, it is open for members and non-members, and we also open up for companies which are, outside Selangor. If they want to attend on online mode, they can also do that with a different rate. Okay. And for those of you who attend physically, you will be entitled to get this latest publication of MEF, which is Probationers and the Law, which later on, if let's say, if you were to sell these books, okay, our books are not available in the bookstores. They are exclusively available in MEF. So you will be getting a copy of the book there right now. So we move on to another service, which is big data research information. They fall into the three categories: surveys and publications, library resource center services, as well as economic and labor data. Okay, now the books that you see on your slide, okay, this is the publication which is currently we are selling. Okay, it is about to we are coming out with 2022 salary survey for executives and salary survey for non-executives 2022, which currently we are in the final process of end of this month or early December, we will come out with the findings, where normally we will give it to the press, yeah, on the projection of, we call it interest, not in, something wrong with the line, is it? I think there's something wrong with the line here. Okay, all right, now, because the slides, have the slides on here? Yeah, because mine. You hold on now, let me just, sorry, okay. I reshare the slide, sorry, yeah. Okay, I think it is this one, isn't it? Okay, sorry for the interruption. Okay, now, so the findings of the survey, normally we will call the press, yeah, for press release. We will make press release, and like, the samples there, you can see it will come out in the newspaper lah. The projection of the increment. I mentioned that the interest, sorry, increment, as well as the projection of the bonus payment, whatnot. Okay, now. So we also have other survey series, say, for example, like the fringe benefit survey and so on, yeah, as you can see on the slides. Okay, we also have IR series, where currently, as you can see on the slide here, like Practical Guide to Human Resources Management. This is one of the publications which I always like to promote, because for HR practitioners, it's best for you to have this publication. So we came up with the second edition, and kalau ada permintaan, we come up with a third edition, because I love to say this, in which we normally receive like inquiries from people from the public. They call it MEF, asking sometimes, Puan, do you have sample of letters macam to terminate lah, letters to appoint whatsoever. So we cannot give, because these are confidential documents from our members. Jadi, the management, we decided to come up with templates, templates where, because this is based on the expertise of our pool of experts in the IRT, they came out with the practical guide. All right, now, so buku-buku lain juga lah, and Probationers and the Law is also one of the books which I mentioned tadi. If let's say you attend or you participate in our IR conference, which is to be held next week, the package is you will be receiving a copy of the book, which is going to be launched, during the IR conference. Okay, now, so MEF Academy, of course, as MEF, we are a registered training provider with HRDC. Okay, so we have a subsidiary, which is this. It is a subsidiary of MEF, and we conduct trainings on HRM, HRD. We conduct trainings on IR. We conduct trainings on OSH. Yeah. We also collaborate with industry specialists. We also have academic programs for diploma, short course certification, and then we also have diploma, degree. Yeah. And we also have conferences and seminars. Okay. Now, as I mentioned tadi, our courses are claimable from HRDC. Okay, now, so other MEF events, which currently for this year, we have started going physical, because before this, it was like online semua, kind of things. Okay, baru-baru ni, like we have like macam 2-day seminar on practical implementation of EA with latest amendments. This is like a roadshow. Just completed the one in Penang. Kalau ada permintaan, please contact MEF. Yeah, we will probably have another series of seminar before the implementation on the 1st of January nanti kan. Okay, now. So lepas tu yang gambar yang tengah tu, which is kita dah 13 tahun with Lembaga Hasil, we conduct the text webinar. Okay? Maybe next year kita buat seminar pula. Alright, now. And then lepas tu we also participate actively. Dan itu ya Hari Koperasi baru-baru ni. Okay, now. So on membership, okay, a quick glance of what MEF membership is. Kita ada 2 classes of membership, ordinary as well as association membership. Ordinary members ni applicable to any company for that matter. You are a registered business entity. Okay, you have employees. Okay, you can join us as a ordinary member. Kalau single company, it is like an enterprise or maybe a new startup, an enterprise. Lepas tu, perhaps a sendirian berhad. Okay. Kalau group tu, it's something like you have subsidiaries. Okay, subsidiaries, but dengan syarat, the subsidiaries tu, the HR functions are centralized to the holding company. Then you can opt to join as a group, because at the end of the day, kita punya membership fee ni is being determined by the total workforce of the organization. Yeah. Okay, now I move on to the next slide, which is the how much you've got to pay. Okay, you must be wondering. Okay, kita ada we call it a one-off payment of entrance fee, slab processing fee, RM500. Okay, now, and annual is being paid annually. Yeah, it is based on workforce. The first 100 employees, RM10 per employee. Second 100, RM8. Then third 100, RM6. After that will be RM1. However, it is subject to minimum of RM1,000, maximum of RM6,000. Kalau let's say you have 5 orang, it's still 1,000. Kalau you ada 80 orang, it's still 1,000. As long as it does not exceed 100 orang, it is minimum, subject to minimum of RM1,000. So it is around RM4 per day lah. RM4 per day, or maybe RM83 sebulan lah, lebih kurang macam tu. Maximum tu RM6,000 tu kalau as long as your company ada 3,900 orang ke atas, then you pay ceiling dia RM6,000. Okay, right. So kalau association, this one 6 categories ni semua ni industry group lah. Okay, just a quick glance. We have like insurance employers, kita ada commercial banks, kita ada hotel employers, kita ada chamber of commerce, kita ada timber industries, plastics manufacturers, kita ada financial planning, contoh-contoh restoran Muslim, pengusaha, and then agricultural producers association. Ini contoh-contoh lah. Right now. So for ordinary and association membership growth, as you can see here on the bar chart there. So as of now, kita ada dalam 6,500 lebih ordinary members, in which just bear in mind the MEF dia punya membership ni, it is not compulsory. Jadi macam it is like on voluntary. Let's say if you feel the MEF can be of service to you, can be of relevance to your day-to-day work, particularly the HR people, and then for the employers, you would like to be in the path, in the correct path of employing people, in which katakan, you follow the employment laws dan sebagainya, you become MEF member. Okay, jadi ini sekarang ni, setakat ni, kita punya membership cover about 2.9 million employees of private sector employees in Malaysia. Okay, now location-wise, as you can see, kita ada subsidiary. We don't call it subsidiary, we call it branches. Tapi as I mentioned earlier on, that we operate from nationwide lah. So for Northern Region, we have an office in Seberang Perai, in Seberang Jaya, and then for Perak, we have an office in Ipoh. Kebanyakan members kita adalah di Central Region. Central Region covers Selangor, Putrajaya, KL, Negeri Sembilan dan Melaka. And then we also have members in Johor, the state of Johor itself, yeah. And then for East Coast, kita ada 3 states there. So our office is located in Kuantan. And then we have East Malaysia, Sabah dan Sarawak. Others tu kita ada companies which are registered in Singapore, so they operate in Johor, and then they become our member. Okay, now, okay, this is, we call it NMI. NMI is a monetary reward scheme. Kalau kata you are currently our member, okay, you introduce a company which are non-members to become our MEF member. Jadi, as an introducer, we will reward you 450 ringgit. To you, not to your company. You are called a referral. Okay. Tapi kalau TNC applies ni, meaning that kalau your company, your own company join, you cannot become a referral lah. Something like that. Jadi, this NMI scheme is open up to 31st December. Okay. Now, yang ni also another value added service to MEF members. Okay, for those companies employing foreign workers. Okay, jadi kita ada collaboration with MAS Malaysian Airline. Jadi new service to provide discounted MAS flight tickets for foreign workers. Cuma ke destination yang ni je lah, from to and fro Dhaka, Bangladesh ni, Kathmandu, Hanoi, Jakarta, Bali, Surabaya and Medan. Jadi kalau ada apa yang you like to get the service, you can always contact MEF through that number which is on the slide. Okay, now, okay, ni tadi the IR conference. Okay, this is a super special membership offer in which, for those of you online now, if you are a non-member, tapi after listening to our webinar today, in which you think that it is worthwhile to consider becoming a member, you register before the 15th of November, you are entitled to get 1 free seat online participation ticket for the IR conference, which is to be held on the next week, 16 to 17 November, which is worth 1,200 ringgit. Okay, so please consider this seriously. Okay, now, so thank you from the MEF team, in which if ever you have any inquiries, you can call us up at that number, or you can always visit our portal, and we also are very actively in our posting in our social media, right? And any inquiries on membership, you can always contact us at that MEF membership at mef.org.my. So with that, thank you so much, and sorry for any hiccups ke tadi, ada apa-apa masalah sikit. So we are a friendly team in which kalau ada apa-apa, you like clarification ke apa, please do give us a call or contact us through the website dan sebagainya. And for those of you who have contacts in Ipoh, Perak, this week actually on the 10th of November, we are going to have a similar program tapi with different topics of IR and OSH to be held at in Ipoh Perak at a hotel lah. Jadi just contact us lah if you would like to attend, or maybe you have a friend in the office is located in Perak ke apa, please give us a call, then we will send you the information. Sorry. Okay, and then we also have face-to-face soon in Kuantan with a different speaker, which is Datuk Jalal, another senior November. So what you can do is you watch out for the MEF social media postings, and you have any inquiries, please give us a call. Yeah, or put up your inquiry on our email, mefmembership@mef.org.my. With that, thank you so much and have a good day.
Thank you, Puan Hasina, for the presentations. Yeah, okay. If it is good to be associated with MEF, yeah, especially yang NMI tadi tu. Sorry, 400. Excuse me. So sorry. Saya baru baik daripada batuk, so sorry about that. Okay, 450 kan is a very amount yang banyak lah, bukannya senang nak dapat 450 tu. Thank you Puan Haslina for the info given. Okay, we are moving to our next agenda, which is by our Executive Director, Datuk Hj Shamsuddin Bardan, bersama di sini on the topic of employment, termination and layoff benefit regulation 1980s. Dipersilakan Datuk, without further ado, dipersilakan Datuk, the floor is yours.
Terima kasih Khalida. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good afternoon to all the participants. Yeah. And thank you very much for attending this particular webinar. And I hope you just enjoy the discussion that we're going to have on this particular topic on termination benefits. Yeah. And this is, I would say, a topical topic, especially coming year 2023, when the economy is expected to be very much challenging, and the World Bank and IMF had forecasted that next year 2023 will be more like a recession year, and of course during recession a lot of things can happen. The labor market contracted, the economy contracted, and some of you may have to do the unavoidable step to reduce the number of your employees. And this is where the issue of termination benefits will come handy. And of course, it's important for you to actually really know what to do and what is your liability as far as termination benefits is concerned when you do termination exercise like retrenchment or BSS, or even if for certain reason some of your branches need to be closed, things like that, and of course the issue of termination benefits will arise. So I would of course take the participants through to this particular regulation. Employment termination and layoff benefit regulation is quite an old regulation in 1980. And of course, the interest on this particular regulation is now much enhanced in the sense that, the scope of Employment Act recently had undergone a major revamp, a major amendment, where now all employees from top to bottom are really covered by the Employment Act. Yeah? And of course, this particular regulation is being enacted based on the provisions of the Employment Act. Yeah? And of course, just to glance through the Employment Act, yeah, the Employment Act is, of course, applicable to West Malaysia and Wilayah Persekutuan Labuan, And in Sabah and Sarawak, they have their own Sabah Labour Ordinance, and Sarawak, they have the Sarawak Labour Ordinance. So the Employment Act 1955 will not be applicable to the Sabah and Sarawak. And of course, this is the amendment that we are talking about in a sense that, the amendment was approved by Dewan Rakyat on 21st March 2022, and 30th March 2022, Dewan Negara had also uh, passed the bill. And of course, the Yang Di-Pertuan Agong had given the royal assent on 26 April 2022. And of course, it was gazetted on 10 May 2022. These particular amendments were drawing a lot of attention, especially when in 2022 we are not doing that well as employers. We are still recovering from COVID-19 situation. And of course, the intention of the government to implement the amendments on 1st September 2022 had drawn a lot of attention from the employers alike. And of course, as MEF, on the behalf of employers, we actually had appealed to the government that the 1st September implementation be deferred to another date. And when I raised the issue at a meeting with the Minister of Human Resources, at that time, the minister said that, of course, they need to get the views of the cabinet before the ministry can decide. And Alhamdulillah, basically the proposal to implement on 1st September was in fact being deferred to 1st January 2023, and in fact we are given a 3 months extension. Of course, 1st January 2023 is fast coming up. We are now in November already, so December will come and January will come, and of course MEF had made the calculation on the impact of the amendments to the Employment Act itself. So you're talking about additional cost to the employers, which is not cheap really. We are talking about 1 billion per month kind of thing, increases in the cost, thing like that. Yeah. And of course, this is just to convey to the participants here that the amendments that are going to be implemented in 1st January 2023. Of course, within the Employment Act, there are so many regulations being enacted or made by the minister. The main difference between a regulation and that of an act is that for an act to be made, the bill or the document must first be presented and approved by the Dewan Rakyat, Dewan Negara, and Agong. Whereas for a regulation, this is just being made by the minister, because normally the minister is empowered within the main act to come up with a regulation. And one of the regulation that had been actually made by the minister is the Employment, Termination, and Law of Benefit Regulation 1980. So let us perhaps concentrate on this particular regulation, because I say this can be very handy knowledge for you when the situation of the economy is expected to be not really that good in 2023 itself. Yeah. Of course, what is important is we know that the coverage of the law only apply to employees within the definition of Employment Act. Yeah? And of course, what is important for us now to understand is that with effect from 1st January 2023, all employee with contract of service, all employees are actually covered by the Employment Act. But of course, there are certain category of benefits that will not be applicable to certain classes of employees. So as far as termination benefits, we need to understand who are employees that actually can claim for termination benefits. And of course, in looking at the various stages of the amendment to the capping of the coverage of Employment Act, I just show on the screen here the kind of stages that we had gone through from 500 way back in 1977 to the current 2000 with effect from 3rd April 2012, yeah. And of course, in 2023 January, this capping of 2,000 or so is going to be increased to 4,000 ringgit. Yeah? And when we talk about termination benefits, who actually can claim for termination benefits? Yeah? Of course, all these people that we are talking about are employees that have a contract of service, meaning that someone who is employed by the company, by the employer, normally they would be engaged under a contract of service, and these people are actually now covered by the Employment Act from top to bottom. In fact, the CEO and to the lowest category of employees in the company are going to be covered by the Employment Act come 1st January 2023. The thing is basically to say that as far as people who are earning more than 4,000 ringgit, yeah, and they are not within the second category of manual labor or those people operating mechanically propelled vehicle or those supervising manual labor. So if they are not within that category and they earn more than 4,000 ringgit per month, then of course they cannot claim for termination benefits, even though these people are covered by the Employment Act. So as far as coverage of Employment Act, so long as they have a contract of service, immaterial of their wages per month, they are actually covered by the Employment Act. The only thing is that for those people who are earning 4,000 ringgit, earning more than 4,000 ringgit per month, and they are non-manual, they are non-mechanically propelled vehicle employees, yeah, and they are not supervising manual laborer, then this group of people cannot claim for termination benefits. Yeah. So the first category that you need to understand is that whether their earnings are actually exceeding 4,000 ringgit. If they are earning, generally speaking, exceed 4,000 ringgit, then they are not entitled to claim for termination benefits. But there are special class of employees where the law say that doesn't really matter how much they earn per month. They may earn more than 4,000 ringgit per month, but if they are a manual laborer, then they are actually still entitled to the full benefits of the Employment Act, including termination benefits. So you need to ask ourselves, who are really manual laborer? Yeah. So if you look at an old English case, Stone versus Haggard, yeah, in this particular case, the employee concerned is an engineer by profession, and in this case was a very old case in the 1920s kind of thing. So the employee concerned was engaged by the company to diagnose the faults of the radio. Yeah, and apart from diagnosing the faults to the radio, he ended up in repairing the radio. So the question is that whether this particular person who is an engineer by profession is actually a manual worker or not. So the court in England at the time said that yes, this person is a manual laborer. Yeah. So coming closer to our side, uh, I personally had done a particular case for KL Hilton. where this particular employee was promoted to the position of executive chef, assistant executive chef, and he was paid at that time 4,000 ringgit. And the contract clearly say that the Employment Act doesn't apply to him. And of course, later on, he complained that he was working long hours. He was working on rest days, working on public holiday, and the company didn't pay any additional payment to him. So he said that he should be entitled to the full benefits of the Employment Act because he claimed that as an assistant executive chef, he is really a manual laborer. Yeah. So of course he argued that as an assistant executive chef, he has to uh, clean the raw materials to be used for cooking. He has to cut the raw material into smaller pieces, and he has to cook the food. Yeah. So he said that all these work are manual workers. But of course, on my part, we argued that cooking is not manual work. Rather, cooking is an art. How much salt you want to put in, how much pepper, and how much spices are all actually as part of art of cooking. Yeah. So at the end of the day, the labor court actually decided that an assistant executive chef is not a manual worker. So he failed to establish that he is a manual worker. But then he actually also argued that he is a supervisor of manual workers. But obviously, in the kitchen, they have manual workers such as stewards and other employees in the kitchen, and of course he argued that he is supervising manual workers. Yeah, but if we look carefully at what the law is, the law say that the supervisor must supervise manual workers in and throughout the performance of the job, meaning that he actually does not do any other job except supervision. But of course, I argued that as an assistant executive chef, he has to actually attend management meeting daily, at least 30 minutes. He has to order the raw materials for cooking, and he has also to draw up schedule for work of the kitchen staff, thing like that. So in that sense, he is not supervising 100%. Rather, yes, he supervised, but not 100%. In that sense, he failed to actually prove that he is actually supervising manual laborer in and throughout the performance of the job. So in that case, he also failed to prove that he supervises 100% of the manual workers. Yeah? Then, of course, the other part is that the exemption comes when uh, employees actually operate mechanically propelled vehicle. This is more like mechanics and drivers uh, that are actually performing the job for commercial purposes. These are the three category of employees that are actually still covered by the Employment Act, irrespective of their wages, but we look more on the nature of job they do. So in that sense, if they are terminated, then then they can claim for termination benefit. So in general, people who are earning 4,000 ringgit and less, and people who are performing manual work, or people operating mechanically propelled vehicle, and people who supervise manual workers 100% of their job, then these people can claim termination benefits if their contract of service is terminated. And going to the regulation proper, yeah. So we have to actually look at Regulation 3.1, which says that employees that actually have worked for more than 12 months can claim for termination benefits if their contract of service is terminated by the employer, or if the employee is laid off within the meaning of Regulation 5. So later on, we can look at what does the Regulation 5 say. And of course, under the law, continuous contract of service for less than 12 months, but if they have more than one contract and the intervening period, the gap between the two contracts is not more than 30 days, so they say that the contracts are deemed to be continuous. So assuming that we employ an employee for 6 months from January, 1st January to 30th June 2022, yeah. And of course, we offer another contract of 6 months from 1st July to 31st December 2022. And in that sense, there are these two contracts. Each contract is for 6 months, but then the gap between the two contracts, actually there was no gap at all. So in that sense, the contracts are deemed to be continuous, and in that case, the contract will be at least 12 months. So of course, in order to break the continuity of the contract, the gap between the two contracts must at least be 31 days. So 30 days is not enough because the law say that the gap must be more than 30 days. So the gap must exceed 30 days. So exceeding 30 days mean at least 31 days. Yeah? And of course, the other part is basically the law says that termination benefit will not be payable when the employee is terminated due to retirement. Retirement based on the contractual retirement age. The second exemption is when the employee is dismissed after due inquiry, or if the employee concerned resign voluntarily. Yeah. So there are three major exemptions granted by Regulation 4.1 of the Termination and Layoff Benefit Regulation, where the employer is not liable to pay termination benefit in cases of retirement, in cases of dismissal, in cases where the employee concerned resign on his own accord. Yeah. So going deeper a bit on the retirement, yeah, the laws say that the employee who is retired based on contractual retirement age is not entitled to claim for termination benefits. Yeah. So of course the retirement age must be stated in the contract of service or in the terms and condition of employment. So it is not sufficient for the employer to argue that actually, the company rely on Minimum Retirement Age Act 2012 to actually provide for retirement of the employee. So what the Employment Act says, what the regulation says basically is that the retirement age must be provided for in the contract of service or in the terms and conditions of employment. And of course, I would urge all of you to check back the company's policy, whether it is stated clearly that the employees are going to retire on attaining the age of 60 years. So the question is that may arise will be, when should the employee be retired? Of course, the contract normally provides that the employee will reach or will retire on attaining the age of 60 years. So when do the employee attain the age of 60 years? Is it one day before the birthday, or on the birthday itself, on the day, or on the day immediately after the date of birth? Yeah. So of course, looking at the Minimum Retirement Age Act and also looking at the wordings on retirement clause, so we say that the employee should be retired on the day that the employee celebrated his 60th birthday, not one day before, not one day after. So the retirement must be when the employee attains the age of retirement, 60 years, that is the date that he celebrate his birthday. So important that he's retired on that particular day, so that the company can argue that the employee concerned is retired based on the contractual retirement age. And the other thing is that, we do employ people who actually retired from the company. So the most important thing is that there ought to be a proper retirement letter issued by the company. It is not a termination, but it is a retirement, telling the employee concerned that the employee is retired upon him attaining the age of 60 years. Yeah? And of course, in order for us to avoid any situation of the contracts before retirement and after retirement deemed to be continuous, then we have to have a gap. So for an employee whose wages exceed 4,000 ringgit per month, uh, there is no need to have at least 31 days gap. It is sufficient for the employee concerned to be given 1 day gap before he's offered a new contract of service. Yeah? And for employees with wages of 4,000 ringgit a month, yeah, or not more than 4,000 ringgit a month, and the employee is actually a manual laborer, or the employee is operating mechanically propelled vehicle, or the employee supervised manual laborer, 100%. So the intervening period between the two contracts, before retirement, after retirement, must actually be more than 30 days. So we say that more than 30 days mean the gap between the two contracts must at least be 31 days. Yeah? And of course, the exemption granted to the employer. Yeah, this is the what regulation 4.1 provides. But question is that when the employee's contract is ended due to frustration of contract. Yeah, frustration of contract can arise because of many things. For example, the employee concerned is being jailed for certain criminal offences, or if the employee concerned is detained under the Dangerous Drug Act, for example, yeah. So that detention normally is for quite a long period of 4 years, 5 years, thing like that. So the question is that when the employer actually issued a letter of frustration of contract, yeah. Remember, frustration of contract is not one of the exemption granted under Regulation 4. So question is that whether the employer is liable to pay for termination benefits. I had done a case on this at the Labour Court for Sri Jaya Kenderaan, where the employee concerned was detained by the authorities for under the Dangerous Drug Act laws, for 5 years. So when the employee concerned was, of course, the company issued a letter of frustration of contract about 2 months after the detention. And the employee, when he was released from detention about 5 years later, filed a claim for termination benefits at the Labour Court. Yeah. So, of course, what the company argued really was to say that it's not the fault of the employer that the employee got detained by the authorities. So we say that it's not something that is provided or envisaged under the law that the employee should be enjoying the benefits from his own wrongdoing. So we say that even though the list in 4.1 doesn't include frustration of contract, it is not the intention of the legislature to actually provide for termination benefit when someone is whose contract is ended due to frustration of contract. And of course, the other part is medically bought out. Whether when an employee is medically bought out through SOCSO for the employee to get invalidity pension, whether the employer is liable to pay for termination benefit. In fact, many employers are playing hide and seek with the employee concerned, not wanting to end the contract for fear of being liable to pay termination benefit. So, in fact, there is nothing to worry really. But of course, we say that when someone is medically boarded out, we don't call it as termination, but rather we say that the services is the employee concerned is medically bought out from certain date when the SOCSO panel actually had decided so. So, in fact, when the company issued a letter, we don't call it as termination letter, but it's just a medically bought out letter so that the company is not going to be liable for termination benefits. Yeah. And of course, the other part is when the contract of service of the employee is terminated for breach of contract. Yeah. This breach of contract may arise because of absences for more than 2 consecutive working days without any prior approval. Yeah. And of course, the contract is terminated under Section 13 for breach of contract or willful breach of contract. So in that sense, of course, again, the employer should not be made liable to pay termination benefits under the principle that employee cannot use his own mistake, his own wrongdoing to claim benefits for himself. Yeah. Fixed term contract, ladies and gentlemen, question is whether the employer is liable to pay for termination benefits when the employer did not actually offer a new fixed term contract to the employee concerned. Yeah. So we have to go back to what the law provides. Section 11 of the Employment Act states that a fixed term contract comes to an end when the contract reach its deadline. Yeah. So, for example, if the contract is for 1 year from 1st January 2022 to 31st December 2022, so come 31st December 2022, the contract reach its end period. So when the contract reach its end period, the contract is no longer valid. So in that sense, the contract come to an end. The employer is not terminating the contract, and as such, the issue of termination benefit would not arise. But of course, we need to be very careful. We are not terminating a fixed term contract, but rather the fixed term contract comes to an end on its own course. And in that sense, what the employer need to do is not to issue any termination letter, but just to inform the employee concerned that the contract of service will come to an end on the appointed date here. So we can see that even though Regulation 4 didn't provide all this issue about frustration of contract, medically bought out, termination based on breach of contract, and also fixed term contract ending, we know that we can argue with the Labour Department to say that for this kind of cases, termination benefit should not arise. Of course, this is just to share with the participants here the Royal Selangor Club place, where the Labour Court actually had provided or approved the termination benefit as claimed by Devagi, yeah, when his contract of service was terminated for breach of contract, absences, things like that. So the company appealed to the High Court, and the High Court say that it is not the intention of the Act to provide termination benefit to an employee who will fully breach an employment term. So don't worry for termination benefit. It is not applicable in cases where the contract of service is terminated for breach of contract. And of course, where there is a termination, but the contract is renewed by the employer on terms and condition not less favorable, and the contract the service continues, then of course in that kind of situation there is no termination benefit payable. Yeah. And the other part is basically when the employer actually had offered a new contract or service or to re-engage the employee concerned, so there is this termination benefit we will not apply. Yeah? And of course, when the employer offered a new contract or service to the employee, and if we reject the offer unreasonably, then of course, in that kind of situation, the issue of termination benefit doesn't arise. So we come to Regulation 5 to look at what can actually happen uh, when the employee is not given work for a certain period, or when the employee is not being paid any wages for a certain period. And this is where, in that kind of situation, the employee contract of service is deemed to be laid off. Yeah. Of course, in this kind of situation, the employer, if the employer does not provide work for at least 12 days in a period of 4 consecutive weeks, in the sense that the employer must provide 12 days wages for every 28-day period. Then, of course, if the employer failed to do that, then the employees are deemed to be laid off. Yeah? So that is important for employer in order for us not to be facing the risk of employees claiming for termination benefit for non-payment of wages or non-provision of work. We must actually give wages of at least 12 days in a period of 28 days. Of course, if you look at Section 16, the estate industry is quite different because in the estate, the virtue of Section 16, employees are guaranteed 24 days wages in any given month. So it's quite different from the rest of the industries. This is the amount of termination benefits that the law provide. For less than 2 years service, it is 10 days wages. 2 to 5 years service, it is 15 days wages. More than 5 years service, it is 20 days wages for every years of service. So in order for us to actually pay the rate of termination benefit, the law provides for what they call it as average through days wages. So what the law states is basically you take the last 1 year wages prior to the termination, and then of course divide by the number of days in the period, so that you can decode it through include basic wages plus all the contractual allowances. Yeah. And of course, it doesn't include the value of accommodation or superannuation scheme or cases of payment that is related to transport or bonuses, whether contractual or not, or sense, the wages as defined by the Employment Act would necessarily include overtime pay or, payment for things like that, so long as the employee concerned is working, and of course that payment is being made in the last one year wage period. Yeah, so you got to take everything that you had paid for the last 1 year, divide by the number of days within that particular year, and then of course then you will get what we call it as average through days wages. It is not ORP, but it is what they call it as average through days wages. Yeah? And of course, within the law, Regulation 8 provide for cases of payment of termination benefit if there is a change of ownership. But of course, we got to understand what does change of ownership means. Yeah? And of course, in the Malay Rango Estate case, this particular case, the shares of the Melerengo estate were sold 100% to Gemas Baru Estate Sdn Berhad. So the question is that when the shares were sold by 25 owners to Gemas Baru Estate Sdn Berhad, whether this amounts to change of ownership. Employees actually are claiming for payment in lieu of notice and also termination benefits. So in this particular case, the High Court actually decided that the changes in the ownership of a business does not arise if it is just a mere sale of shares. And of course, the High Court actually was also referring to shares of public listed company that are traded at the Kuala Lumpur Stock Exchange. Does it mean that if it is accepted as a change of ownership, then of course that would create a lot of uneasiness for companies that are whose shares are traded in the Kuala Lumpur Stock Exchange. So the court say that change of shares does not amount to change of ownership in the Melerengo estate case. Yeah? And this is, of course, what the Supreme Court say about Regulation 8 itself. Yeah? In fact, the court say Regulation 8 of the regulations cannot be construed to deem termination of the contract of employment of the employees where there was only a change in the ownership of the shares of the company. Then what does amount to actually a change of ownership? We look at the Dunlop Estate case, uh, where the Segamat estate, the two estates were sold to Industrial Oxygen Berhad, yeah, and Dynamic Plantation Berhad. So the Segamat estate of Gombali and Pailang was sold to the IO Industrial Oxygen Berhad, yeah, and of course the new owner offered employment on terms and condition not less favorable, and service continues. And the employees actually accepted the offer. Yeah. So the court say yes, in this particular case, there is what they call it as change of ownership. So what happened is that Dunlop actually didn't actually terminate the services of the employees. And if you look back at the provision of Section 13, Para 3, subsection F, the law says that if there is a change of ownership, then the old owner is actually liable to issue notice of termination. So in this particular case, since Dunlop failed to issue notice of termination when the two estates were sold to Industrial Oxygen, then the employees are claiming for what they call it as payment in lieu of notice. The issue of termination benefit doesn't arise because employees had accepted the offer of employment on terms not less favorable, and also service continues as offered by Industrial Oxygen. So the issue here is just question of the granting of termination notice. And since the employees were not given the notice, employees are now claiming for payment in lieu of notice. So the employees filed the case at the Labour Department, and the Labour Department actually had, or the Labour Court had rejected the claim. So the employees appealed to the High Court, and the High Court actually affirmed the Labour Court decision, meaning that there is no need to give notice of termination or pay in lieu of notice. And the employees appealed to the Court of Appeal. Yeah? And of course, this was decided by the majority, not a unanimous decision, where the majority decided that employers are obliged to give notice of termination. And since Dunlop failed to pay to give a notice of termination, the Court of Appeal actually directed Dunlop to pay to make payment in lieu of notice. So the amount was about 231,000 ringgit, uh, to 231,000 ringgit. And of course, when there is a change of ownership, ladies and gentlemen, I had discussed with you about the need for the old owner to actually terminate the contract of the employees. Yeah? And of course, the new owner, within 7 days of the change, yeah, must remember that the offer cannot be made earlier than 7 days of the change. It has to be made within 7 days of the change of ownership. The new owner may actually offer continuous employment with terms and conditions not less favorable, and service continues. Yeah. Of course, if the employee reject the offer made within 7 days on terms and conditions not less favorable and service continues, the employee shall not be entitled uh, to claim for termination benefit. Yeah. But of course, if the offer is on terms less favorable and service not continues, and if the employee reject the offer, then the employee can claim for termination benefits. Yeah. And as far as termination benefit is concerned, that amount of payment must be made not later than 7 days after the effective date of termination. But I think here the participants don't have to worry, because normally for the last payment made to employees, the payment can only be made after the LHDN had given the tax clearance. Yeah, so it may take more than 7 days, thing like that. And of course, we see that Section 5 of the Employment Act say that the Employment Act is subjected to any other written laws. And of course, the LSDN laws override the provision of the Employment Act. So, ladies and gentlemen, I had actually, take all the participants through the issue of termination benefits under the termination and the off benefit regulation. So, thank you very much, and perhaps we can actually have a question and answer session after this. Yeah. Thank you very much.
Thank you, Dato. Thank you. Thank you for the presentations. Okay, move on to the Q&A from the pigeonhole. Okay, we have questions. Question 1, ya Dato. What are the consequences if a retired employee's new company is issued with less than a 30-day gap? 30-day gaps.
There is, I would say, the possibility of the employee, when the contract is eventually not required anymore, meaning that the employee is terminated by the company eventually, he may claim for termination benefits, yeah, depending on how we actually handle the contract post-retirement. And when he make that kind of claim, then he may actually say that he's not claiming for the contract uh, post-retirement only, but he's claiming even for the services prior to retirement. So that may amount to say 30 years service or even 40 years service, thing like that. So this is where, again, I would say that it is important for the employers to make sure that there is a gap, sufficient gap, at least 31 days for those people earning less than 4,000 ringgit, yeah, or 4,000 ringgit and less, and those people who are manual workers people who are engaged in mechanically propelled vehicle, people who supervise manual workers 100%. So for this category of employee, I would say that it is important for us to introduce a gap of at least 31 days, yeah, before we can actually make the contract post-retirement effective. Yeah.
Okay, noted. Hope it is clear, yeah, to the participants that at least we have to have a gap of 30 days. Okay. Second question. This one, I think daripada chat box from the MS team, right, Datuk?
Yeah.
Is foreign employees who depends on EP approval considered as fixed term contract when the EP is not approved? No termination benefit to be paid by the employers.
Yep. So that depends on how we actually issue the letter ending the contract. Yeah? So if the contract actually is not able to be renewed because of the employment pass issue, then we say that the contract comes to an end because the authorities did not grant a new employment pass for his employment. So don't use the word termination, because if we use the word termination, then the employees will be tempted to claim for termination benefit. And of course, the issue basically, when you look at from the legal angle, if we actually call our document ending the contract as termination, then it's going to be difficult for us to rebut the meaning of that termination, because remember, termination benefit will only arise if the employer terminates the contract. Yeah, so it is for the employee to actually prove that his contract is terminated. Uh, and of course, then of course, it's for the company to say that basically termination doesn't arise in this kind of cases. Yeah. So of course, the other part is that just now when I talk about the fact that if the employee is dismissed after the inquiry under Section 14 of the Employment Act, the employee is not entitled to claim for termination benefit. But what really happens is that under Section 69, even if the employer dismissed the employee concerned after due inquiry, the law under Section 69 of the Employment Act allows the employee to file a claim for termination benefits within 60 days from the date of the dismissal. So in that particular situation, of course, the company has to prove two things. First is basically the dismissal is done after a due inquiry. And secondly is that the employee was dismissed with just cause or excuse. So you need to actually bring in evidence or witnesses to court to prove these two things, that the dismissal was done after due inquiry, and secondly, the dismissal was based on just cause and excuse. Yeah. So these elements has to be proven in court. So if the court agrees with the company to say that, yes, the company had conducted due inquiry and the employee was dismissed with just cause and excuse, then the labor court may reject the claim as filed by the employee for termination benefit.
Okay, noted. Okay, moving on to next question, ya Dato. We have one question voted here. Okay, the question is like this. We have rehire employees for the different project. The new offer letter issued with all fresh entitlement. How this affect the layoff or termination benefit for this group of employees?
Yep. Again, this may actually be more like a project-based employment, and it is quite similar for fixed-term contract. And of course, when the project is completed, the company don't have to say that it is termination, but rather that the project and the contract come to an end because the project is completed. So when you actually rehire the employee concerned, of course, again, there is this issue about gap between the two contracts. And if, of course, you're not able to actually provide at least 31 days gap, then later on, if the contract come to real end, in the sense that there is no new projects, thing like that, the employee may be tempted to claim for termination benefits. But again, like I say, the employer can argue that this is really not a termination. It is the contract come to an end because of the completion of the project. And in that kind of situation where the contract come to an end under Section 11 of the Employment Act, employees actually are really not terminated by the employer, and they should not be entitled to claim for termination benefit. That should be the defense put forward by the company in the event there is a claim. Yeah.
Okay. Thank you for the explanation, Datuk. Moving on to issue also on the termination, right? The termination notice of period, resign with short notice on the spot. But actual notice of period is 4 weeks already stated in the offer letter. What would be the procedure? Is it payment in lieu? Employee should pay the employer, or how?
When the employee resign, it is the employee's duty to observe the terms and condition of employment. And if the contract provides for 4 weeks notice, and the employee is not able to provide or serve the 4 weeks notice period, so the employer is entitled to claim for payment in lieu of the short notice. Yeah. And this payment in lieu of short notice may be set off against whatever wages that may be payable to the employee concerned for before the end of the service period. But normally, what really happens is that the employee will just leave employment without giving the proper notice when actually he had taken his last wages, thing like that. So what the company can do is to actually file a claim uh, under Section 69 of the Employment Act at the Labour Department, claiming for payment in lieu of notice. And this can be interesting because, come 1st January 2023, the Employment Act is applicable to all employees top to bottom. So previously, for an employee who earns more than 5,000 wages per month, employers cannot file a claim at the Labour Department. But now, even if the wages is 30,000 per month or 35,000 per month, and if the employee did not serve the proper notice period, the company can always file for payment in lieu of notice under Section 69. So this is something that company may do come 1st January 2023. But currently, of course, employees with wages of 2,000 and less, and if they are manual worker or they are dealing with mechanical propelled vehicle, or if they supervise manual workers 100%, then the company can actually file a claim currently up, of course, to 31st December for payment in lieu of notice. The only problem normally faced by employers is basically the Labour Department will say that they are not able to serve the summons to the employee concerned. And I think this is where employers are actually advised to keep a proper address of the employee concerned. Yeah. And of course, Malaysian style, it would be good if the employer also keep the kampung address of the employee concerned. Yeah. So that at least if there is summons to be served to the employee concerned, the summons can be served at the kampung address if the address given by the employee is not reachable. Yeah.
Okay. The next question, ya Dato, will be, is it true that the last date of service for an employee reaching the age of 60 on the day he celebrates his 60th birthday. This one is on the
Yes, it's true, because the retirement date should be on the date the employee concerned celebrate his 60th birthday. Yeah. So your letter should say that he's retired on attaining the age of 60 years. So that is when he celebrate his 60th birthday. Not one day before, not one day after.
Okay, back to the EP question posted in the chat box just now, yeah. The additional information they would like to know, Miss Gloria would like to know. So in such situation where EP is not renewed by immigration and the fixed term contract didn't have the clause that the contract ends if EP not renewed by immigration, how do we end the contract if it is not called termination?
For employment of foreign workers and even for expatriate, it is a known fact that the contract of service can only be effected with the approval of the necessary licenses from the immigration department. So in a situation where the immigration department did not issue the EP or the employment permit, then of course we say that, we don't say that we terminate the contract, but we say that his contract come to an end because the authorities did not issue a new EP for him. Yeah.
Moving on to the next question, Dato'. If employee under no pay wages, he is granted no pay leave for 12 days or more, is he under temporary frustration of contract? In this case, is he not entitled for any benefit under the EA Act 1955?
No, when someone is on approved no-pay leave, yeah, so it is not going to affect his contract because both party agree that he is not to be paid for certain days during the unpaid leave period. The unpaid leave period can even be 1 year without pay or even half a year without pay, and that does not mean that employee can claim for laid off within the meaning of section regulation 5 because this is agreed upon by both parties. Yeah. The regulation 5 will only apply in the event the company unilaterally, without agreement of the employee concerned, fail to provide at least 12 days work or 12 days wages in 28 days period.
Okay, still on the EA, Dato'. What if there is no contract of employment between employer and employee since before, and the employee is within EA? Do employer need to follow the Employment Act for the termination issue or retirement issue?
Yep. I think this is something that I think we practitioners need to be very careful. Yeah. Uh, Section 10 of the Employment Act says that any employment which is more than 1 month, you must have a written contract of service. Yeah. And the written contract of service must provide for how the service can be ended. Yeah. This means the termination notice. Yeah. So of course, I think employers has to be very careful here, because even as it is right now, failure to have a written contract for someone which is more than 1 month service can be an offense, and on conviction is liable for up to 10,000 ringgit penalty. Yeah. And come 1st January 2023, the penalty is increased to 50,000 ringgit. Yeah. So 50,000 ringgit, and the offense is based on how many times we actually fail to do that for employees. So each employee is considered as one offense. So uh, in the event the contract of service did not exist, surely there is no retirement age in the contract. And in that kind of situation, when the employee concerned is retired purely based on Minimum Retirement Age Act provision 2012, then of course the employee can say that actually his contract, or he is retired not in accordance with the contract of service, because he don't have a contract of service. So in that sense, of course, he can argue that then he should be entitled to claim for termination benefits. Yeah. So the exemption given to employers not to pay termination benefit when the employee is retired is on condition that the retirement is carried out in accordance with the written contract of service. So the retirement age must be provided for in the contract. Otherwise, then the employee concerned may claim for termination benefit. So as a way out, you may have a situation where there is no written contract as far as retirement age is concerned. So 60 years is the minimum retirement age. You can have a higher retirement age, say 61, 62, 63. So if you have someone now reaching retirement age, but your contract is silent, or you don't have a contract as far as retirement age is concerned, I would suggest that you create a new contract. And of course, you don't have to retire the employee concerned on reaching the age of 60. You can say that his retirement is on attaining the age of 61 or 62 or 63, depending on your need. And of course, this retirement age may not have to be the same for everyone in the company. It can differ from employee to employee depending on the needs of the company. Yeah. So you have to manage it in that manner so that you can avoid paying termination benefits when you retire the employee concerned. And of course, the retirement has to be based on contractual retirement age act. If you don't have one, you can provide for it now and plan for the future. Yeah.
Okay, thank you, Dato, for the explanations. Hope it is clear. Okay, moving on to the next question on the medical boarded out here. Is there obligation for employers to pay termination benefit under the medical boarded out, even though after employees serve or complete prolonged illness internally to, on 12, 18, or 24 months?
Yeah. This depends very much on the letter that you issue on medically boarding out the employee concerned. Like I say, many employers are not very certain about this particular issue, and they are reluctant to actually issue any letter of medically boarding out the employee. So more often than not, employers will try to persuade the employee to resign. Of course, the employee can say, "Why should I resign? The company need to issue a medically bought out letter so that this can be shown to SOCSO for SOCSO to start to pay the invalidity pension, because SOCSO need the letter from the employer to say that the employee concerned is really medically boarded up." So once the social panel doctor issue a letter of medically bought out, it is not legal to continue to employ the employee concerned. And if the employer do continue employing the employee concerned who is medically boarded out, employee is taking a great risk, because the employee should not be employed when the letter of medical board out is issued by SOCSO. So what the company need to do is to say that based on the medical examination carried out by the SOCSO medical board, they decided that the employee concerned is no longer fit for employment and be medically boarded out. So you can say that you don't say that you are terminating also, but you can say as such, your last day of service is the date that you issue the letter. Yeah. So and this has to be done immediately upon the letter from SOCSO on medically board out. So there is really no notice of medical board out, or there is no payment in lieu of notice required because it is with immediate effect. Yeah.
One question also on the apa, medical benefits, but this is for the foreign workers. If the foreign workers permit doesn't renew due to employer doesn't want to renew them. Sorry, excuse me, sorry, it's the wrong question. Okay, this is the correct question. If the foreign worker permit doesn't renew due to the medical unfit and not approved by immigration, do employers have to pay compensation to such employees? Yeah, that's the
Really,
question.
there is no need because the employee the ending of the contract is because he didn't actually pass his medical examination. Yeah. And of course, the employment of foreign workers is subject to the employee concern being declared medically fit for employment. Yeah. Of course, there are issues, ladies and gentlemen, that, like I say, 2023 may be very challenging year. You may actually want to send back some of your foreign workers, yeah, and the foreign workers are actually engaged under fixed term contract, and a fixed term contract is a special form of contract in the sense that the employer promised to the employee concerned that he is to be engaged for that specific period, and the employee is really, hoping that he will be engaged up to the end of the period as stated in the contract. This is the meaning of fixed term contract, and if you end the contract midway, then the question is that whether the employees are entitled to be paid wages for the remaining period of the contract itself. Yeah? In fact, there are a lot of debate over the subject matter. And of course, the court had always been looking at a situation where the employee will be entitled to be paid his wages for the remaining period of the contract itself. So in that kind of situation, know that in the previous recession, I had assisted companies to deal with the matter. So at the end of the day, a company and the foreign workers negotiate to make certain payment, but not the full payment of wages due to the employee under the remaining period of the contract. They somehow negotiate and agree to a particular sum. So that resolved the issue rather than having to pay the full liability for the duration of the unexpired term of the contract.
Okay, Datuk, thank you. Okay, one last question before we end the session from the chat box here from Miss Kasturi on the extending of notice period. Is the payment in lieu of the short notice 4-week notice period that claimed by employers is included with allowance? Let's say the basic salary is 3,200 and vehicle allowance is around 400. Some more the employees didn't have his balance salary. So in this case, does the employers have to request a settlement in the and release them?
Yeah, that depends very much on what the contract provide. Some of the contract that I know of say that, the employer or the employee has to give a certain period of notice or payment in lieu of notice based on the basic wages for the remaining period of the notice period. But if the term used is wages, then of course it's wages under the Employment Act and not just limited to basic wages. Yeah, and of course wages. Of course, in this case, if you look at the Employment Act Section 2, doesn't include any payment related to transportation. Yeah, so payments related to transportation will not be considered as wages under Section 2, really. Yeah. So other payments can be actually be part of wages. And when the company demand for the payment in lieu of notice, it should be included as part of the wages payable to the company. So you look at the definition of wages under Section 2. Actually, if you look at Section 2, the Section 2 define what are really not wages. So those are the excluded items. So it is just when you talk about wages under the Employment Act Section 2, imagine yourself is as being a fisherman and you cast your net into the sea. uh, Whatever the items that are within the net are actually not wages. These are considered as non-wages under Section 2 of the Employment Act, the 7 items. So the rest of the payment that you make that is in the sea are really wages. Yeah.
Okay, thank you, Dato'. Thank you, Dato', for the explanation and presentation for today, for this evening. Oh, before we end, okay, don't forget about the MEFIR conference scheduled on the 16th and 17th November next week, yeah, hari Rabu dan Khamis. And if you enroll for membership during this period time, kita akan bagi one online tickets lah for the IR conference, of which worth of 1,200 ringgit. Okay. Do watch out for MEF announcement for our next activities via our social media. Okay. I do saw one questions on the slides presentation. Are we obliged to do that so Dato' ke?
No, just take the question, Khalida.
Okay, noted. Okay, thank you all. Thank you for your time today.
No, Khalida,
See you
I thought you
again.
want Khalida, I thought you want to take the question and not to just leave it like that.
Sorry. Okay.
Can we take the question or not? What question is that?
One more question, ya Datuk. 2 votes here from the apa ni, Pigeonhole on the contract renewal. If we have a yearly renew contract, does the contract need to have the 31 days cap for every renewal?
Yeah. In order to break the continuity of the contract, then it's best that we have at least 31 days break. Otherwise, the contract can be deemed to be continuous. Yeah. And of course, better still, if you're talking about termination benefits, you can make each contract less than 12 months, meaning that if each contract is less than 12 months, then the employee will not be entitled to claim for termination benefits. Yeah, very clear. So what you can do is that possibly, you can have the contract of say 11 months, 10 days, for example, not to say 11 months, 15 days, something like that, because then my worry will be if it is 11 months, 15 days or 16 days, then the authorities may interpret that is actually 12 months. Yeah. So make the contract of less than 12 months. Yeah. And of course, the only problem is the practicality of doing things like that. So we may be able to avoid payment of termination benefits, but then employees may not want to serve our employer in that kind of situation. That's the only drawback on the practical aspect of things. So again, like I say, what is important is that at the end of the day, we say that for fixed term contract, we are not terminating the contract. There is no termination. The only thing is that it is the contract come to an end, but to of course safeguard the interest of the company, we suggest that at least there is a gap of 31 days before we move on to the new contract. Yeah? To make sure that the contract, the subsequent contract, is not deemed to be continuous with the earlier contract. So thank you very much.
Thank you very much. Thank you very much, Datuk, and thank you very much all. I believe one more question. So sorry, Datuk. One last question from the chat. Just now you mentioned, I forgot. Okay. If an employee tendered her resignation with notice of 2 months, but after 1 month she changed her mind and decided to revoke her resignation, can employer ignore her notice to revoke? That was the last question.
Yeah, you know, once an employee submitted his or her resignation, it is really the employer's discretion as to whether you want to accept the revocation of resignation letter. Yeah. So if the employer says, sorry, I'm not going to agree to revoke the resignation letter, then the resignation will be effective. Yeah. So employee cannot actually unilaterally revoke the resignation letter without the consent of the employer. So if the employer didn't agree with that revocation, so the resignation stands and can take effect really.
Okay, thank you. Thank you so much, Dato', for your time, and thank you, participants, for today. For the slides, I believe we can't share it as this is a free webinar, right? Hope to see you again next time. Watch out our news in our social media, IG, TikToks, and also uh, uh, our YouTube. We do post our activity regularly there, and also our website. Hope to see you again soon. Thank you very much. Bye.